Good afternoon, everyone, and thank you for joining us. My name is Edith Tapia. I'm the Policy Research Analyst at Hope Border Institute, and I've been doing the court observation through our Border Observatory program for the last 3 years. And it's my pleasure to introduce Ariel Prado, who's also been a great ally and a source of inspiration for this work.
Hi, everyone. Excited to talk with you today about Court Watch. I work with Innovation Law Lab. I'm a program director based out of Atlanta in Georgia, um, mostly focused on pro se asylum workshops and as of recently, Court Watch. So been really excited to work with Edith and the Hope Border Institute, learn a lot from them, and I'm excited for what y'all are going to learn today.
So we'll go ahead and go through the program today. We've already introduced ourselves, and I know that we'll continue to share more about our experiences as we go through the presentation. And we'll go through why we observe, and hoping that some of the reasons may be similar to what you have or your interest, but everyone has a different reason for wanting to do and take on a project of this magnitude. Then we'll walk through how to plan your visit and getting to know your area, your court a little bit better, as well as the immigration process and the types of hearings you may encounter. We'll also go through the trends that we have been monitoring, but as a model, but of course, again, with every jurisdiction, every part of the country, they may have different trends, so we can just set some examples of what you can do. And then we'll talk a little bit about what you can do in terms of advocacy of how you're going to use this data. And then the resources. And one of the reasons why we decided to do this webinar was precisely that, to share the resources that we are launching today. We're having our new manual it's already up on our website, and you'll be able to access it after this webinar. So I'll give you a good example of a little bit of background reading that we'll be going through today, as well as resources that Ariel is going to share with you once you decide to take on a project like this. And it can be done so in a variety of ways and sizes. So we'll just go ahead and get started with why we observe. One of the reasons why, in terms of the Hope staff, that we wanted to be in the courts was particularly at the middle or the beginning of 2017, there was a series of executive orders that directly impacted immigration policies. And there was very little access to accurate data and accurate information. And we knew that a lot of what we had been observing and highlighting in our report, our first report, Discretion to Deny, may change. And the only way for us to really get out there and see how this policy changes were going to impact our community was to access any space that would allow us. And it turns out, the immigration court, particularly master calendar and bond hearings, are open to the public. So we started going there just to have a way to get information so that we could hold the government accountable and responsible and transparency through this process. We've also learned that by doing so and by incorporating people who, like yourselves, have been interested in doing this, and when you visited our community, we have taken folks there, they learn about the process in a very different way, and they're engaged. And it's a way to just maintain some sort of checks and balances, that the judges also know that someone's watching them. And again, through that, we are able to observe a lot of what is happening and document it in a way that we can use that data to really create not just educational resources, but also perhaps more information that can be useful for litigation or other sources that other allies are working on. And most importantly, one of the things that we have observed, both by taking larger groups as well as by doing it individually, is that we know we have been able to see how judges tend to have a more positive, or at least more thorough behavior when they know someone's watching them. And typically that will translate into a positive impact for the migrant. So that's one of the things that we've continued to hold as, for whatever reason, in whichever manner you do so, by being present in court, you're most likely going to positively impact those who are going through the process. And I know Ariel has also some stories of his own.
Sure. So in Atlanta, kind of the reason that we first started thinking about Court Watch just in our jurisdiction is because of some of the immigration judges we have here who would say some pretty horrific things in immigration court and would treat respondents really, really terribly. And the kind of legal community here came together and was thinking through, well, how can we highlight these issues? Every time we complain about them, they're kind of treated as a solitary or a single issue. We're told when we file a complaint, we get the email back from EOIR that says, you know, we're in receipt of your complaint and we're doing something, but we can't tell you what it is because we have to respect the privacy of the immigration judge. And so as we were kind of brainstorming what possible solutions might look like, kind of in those conversations, I had the chance to speak with an attorney in Boston who had been part of a court observation project several years ago that was really focused on Immigration Judge Ragno. Some of you might know Immigration Judge Ragno, especially the folks from Boston, but he was a judge who was notorious for stopping the record to make a racist joke, being the only one in the courtroom to laugh, and then starting the record again and continuing with the case. Folks kind of documented it, filed complaints over and over again, but nothing happened. And so the kind of next step in that process was to start a court watch program and to start documenting every single time that he did something that you know, engaged in a similar form of misconduct. That he would generally, the practice was to stop the record, make a racist joke at the expense of the respondent, and then continue on with the case. And that court watch effort, in combination with some kind of threatened litigation and a media campaign, was actually able to force Immigration Judge Ragno to step down off the bench. In Atlanta, the judges who are kind of the, you know, I don't have a more articulate way of saying it, the worst, were just recently promoted to the Board of Immigration Appeals. And there's kind of a veneer of professionalism now in the immigration court, even though there's still such a high rate of denials. But what we've learned in having these conversations with folks like the Hope Border Institute and folks who do court watch in other jurisdictions is that the problem of having unprofessional, cruel, sexist, racist immigration judges is not specific to Atlanta. We know that that exists in many other places, in El Paso specifically. And so we're really excited about Court Watch as kind of a tool for shining a light on that. The last thing I'll say before we kind of go on is that I think it's something, I don't have the number in front of me right now, but I think it's something like 87% of all removal orders are issued, or rather 87% of immigrants who receive removal orders in court are not represented. And so what that means is that for that 87% of folks who are getting ordered removed, there's no legal advocate in the courtroom. There's no record to say what happened in that case, which is something that's really scary when we're in the moment of this kind of historical moment where we have a regime that is pushing for mass deportation of immigrants of color. So Court Watch becomes a really important and powerful tool for highlighting, as Edith was saying, the mechanisms by which that agenda moves forward.
Thank you, Ariel. So the first and a very important thing to be aware of that we always like to highlight are the different agencies that are part of the system, the immigration system, and who they respond to. Having just that general knowledge, we know that a lot of people who are on the webinar may be already very familiar with this, but plenty other folks who are interested in becoming may not. So it is important to understand because they're held accountable to different agencies or different umbrella agency, and that sometimes impacts the way a case can move forward or who you are highlighting, like the misconduct, and you know who you may reach out to for clarification or for transparency and accountability, which agency. So in terms of the Department of Homeland Security, they have the Customs and Border Protection and Border Patrol agencies, USCIS, which a lot of the administrative processes that go through the court are usually referred to them, ICE, which is usually the Immigration and Customs Enforcement, and particularly in the interior. But because we happen to focus a lot on the detained court dockets, most of the detention center in the court is housed inside a ICE facility. And so you're also going to see that you're going to encounter a lot of the deportation officer or the attorneys who represent the government are also considered to be under ICE jurisdiction. And then completely separate is the judge himself or herself. and they respond to the Department of Justice. And one really important piece of information that I like to share with people is that when you think about immigration judges and you see that they fall under the Department of Justice, they actually respond to the Attorney General, who's directly responds to the executive branch. Right? So this is very important because we know that they are not independent judges the way that you may think of a federal judge who is supposed to be impartial, who's supposed to be neutral and take evidence into account to make his decisions or her decisions. In the immigration court system, judges respond immediately to the Attorney General, and the orders usually come down from the White House, and they trickle down. So there's a direct connection to the current administration, any current administration. And what we have seen is in this particular one, that has been, has had detrimental impacts and very immediate impacts in the court system. And one of the things that we advocate for is that separation of the branch to be really independent. But another key factor is that because they're also judges, that their decision is ultimately up to them. They have total discretion as to how they move forward, and the law was written in a way that it can usually help someone, a lot of people who are coming without a lot of evidence. But what we see is the opposite, right? Is that we have someone, whether they have evidence or not, they can present a case that's very well, has proof and has representation, has everything. And just because the judge at that point decides that it's not good enough for him or her, or that they don't believe the person, they're denied without very little transparency, or even just taking it up one level will be going to the BIA, which may just take longer. That just means that the person, particularly those who are in detention, will be detained that much longer. So just to highlight that there. I don't know, Ariel, do you want to share anything else there?
No, that was great. Thank you.
Okay, so this is a little bit of that background that I just kind of went through. Immigration judges do the removal proceedings, and they have they have this accountability, or like lack of accountability, as to how they make their decisions. In terms of the immigration court, there are two types of dockets: those who are detained, usually migrants that are being held in detention centers across the country, and then they show up in court. That can be in person. We've also seen the increased use of video, them being video conference in, which presents its own set of complications and due process concerns. But those are the cases that are moving forward and that we monitor the most, because exactly the fact that they are detained, there's less access to them, there's less access to counsel, there's just less access and less, they're just kind of out of mind, out of sight, out of mind kind of situation. And so for us, it's been a priority to document the detained docket. There's also the non-detained docket, which can contain an array of cases that are not just asylum cases or removal cases. They can be, people who have been in the country for many years and who have had the opportunity to, have access to the resources that you can when you're not detained outside in your community. So you can see it, all types of different cases, and you can choose to observe both, or whichever one is closer to you. And for this is for us to just to highlight that the importance of detaining the detained docket is that usually we would be the only kind of like third-party observers for a population that is purposely being kept out of sight, and a lot of their opportunities to have access to things like healthcare, counsel, language interpretation are being denied. So that has a direct impact to their case. Okay, so now hopefully you have been considering, or you talk to your colleagues or to your community about moving forward and going into doing at least a visit, right? So you can see what it may look like. And the first thing that I always like to share with folks that are wanting to go into these spaces is to be aware of the fact that there's going to be pushback, or they may experience pushback, both by the court clerks or just different officials there, people who are guarding the doors. They may ask like who you are, they may deny you access. And so just being aware of that. I always like to highlight as well that as long as you are firm, like assertive, but at the same time respectful, that tends to get you a lot further than, just maybe not knowing what to say or being a little bit, just kind of like pushing the buttons a little bit. So just be prepared for that, because sometimes it is very easily to fall into that trap. So just making that assessment beforehand, and just knowing that you're going to have to take some deep breaths if you encounter this, it's important to just be aware of. The other thing that is just as important to keep in mind and to get your mind ready for is that even though the detention center and the detain docket should not be a criminal court, and this is very different, migrants are often treated as criminals, right? So they are dressed in a way that defines them, or they try to categorize them by level of violence or threat or misbehavior. They can be heavily guarded. They can just, many times, depending on where you are, they may have, just shackles or something. I mean, in the El Paso one, they haven't been, but they are heavily guarded. And so just being mindful of encountering that, and what that may do to you, what that may trigger in you as well. And very importantly, it's also like not being afraid to make eye contact, because most of these spaces tend to be quite small, and you will most likely end up sitting in behind many of the people who are detained. It is very easy and common for you to make eye contact. And I know that I've had students who come up and have asked, like, should I make eye contact? Should I avoid it? I don't know what to do. I feel bad. Like I can leave, and they can't. So there's a conflict, obviously. So know that may be, but I always say that I prefer to make eye contact, because one, it humanizes the person who's there, who's, the system is trying to make them feel inhumane, and strip them of that, and making eye contact and seeing them, right? Like you're seeing them. They know that you're there to, maybe they don't know that you're there to support them, but I think that just that contact usually does make them feel a little bit supported, or like someone is here. And that is very important, just to be aware of that. And having that feeling of sometimes guilt of like being able to walk out, and sometimes avoiding some sort of contact with migrants who are detained at that particular moment. I like to say that, again, it's part of the experience, part of the essential part of humanizing the experience, and being able to take that anger or that frustration of you being able to leave and not them is fuel for what you can do after. But it's also more important to recognize that at that moment, it's not about you, right? So those emotions, you might have to work out through them a little bit, but the importance that you're present there for the migrants themselves. And obviously, to exercise self-care, once you've done this, it's also crucial, because it can be heavy. You may not be aware of what may trigger you or may not, but especially if once you start doing this in a systematic way, it does, and it can take a toll. So making sure that you prioritize self-care is important. So finally, we get to the resources that you'll have access to once you visit our manual. Is that just as important it is to prepare yourself emotionally for what you may encounter, it's also crucial for you to do some pre-readings, right? So just go through some material that we're providing for you, so that you're able to familiarize yourself with what is happening. Many times, when we go into the court hearings, again, we have access to the master calendar or bonds, and this manual goes through what those are precisely, but you may not know what's going to happen. You may not know what stage you're in. So it's important to sort of get some of this information before, so you may be able to pick up on little pieces here and there. Right? So we first have our 2 flow charts. You may be familiar with our first one, which is the Guide to Asylum at the Border, which has been available on our website for a few months now. And we added the master calendar hearing timeline, which is more useful in this context of observing, because you can situate yourself where you are within the master calendar hearings. You may be there for the very first time that the person is before the judge. You may be in one of the continuances, and those tend to go really fast. So sometimes you feel like you didn't really observe much, but again, it depends on that stage, but knowing where you are and knowing what stage and how long a judge spends with each person is also important, right? Or if you're in the bond request part of the hearing, you also know what the decisions can be. And again, these are the hearings that we have access to. So the master calendar, anytime between the initial hearing and when they submit their actual application for relief, or the bond hearing. We will not, and we encourage people, unless you have a strong relationship with a particular person in detention who's going to attend their actual asylum case, their merits hearing. For general practice of observing, we have not been observing individual hearings. Those tend to be closed, to the public, and due to privacy and to respect also the migrants' privacy, we haven't done so, unless, as I said, we've worked closely with either the attorney or the migrant themselves, then we're able to be there and observe and also monitor the trends that are happening there. Ariel, do you want to add something in?
No, I think I have one thought, but I actually want to add it later, and so we're perfect.
Okay, I'll go. So the trends that we have monitored, again, we've been doing this for going on 3 years, and we have been able to see changes in the trends that we're monitoring, but these are pretty constant. And again, they may be different from what you're seeing in your area, but these are constant and broad enough. So one of them is just the power dynamics that are present within a court, whether that's between the judge and his or her staff, whether it's the judge and the ICE attorney or the government's attorney, and then with the migrant themselves, or if they have an attorney representing them, and different levels of authority and how people abuse that power dynamic and that authority that can undermine someone's case. And many times that translates into the due process violations, but not necessarily. Some of these power dynamics also go into what Ariel was saying earlier about judges making racist jokes and comments that are just demoralizing for the person who's there sitting, literally like trying to present their case as to why they should be protected, and then you have the judge making jokes on their behalf, or jokes about them. And so that's important to monitor. Due process violations, that can be anything from language barriers, whether someone is given the opportunity to have a translator or an interpreter, whether that interpretation is accessible, whether it's in person or on the phone. Many times, particularly with indigenous languages, what we know is that many times they will ask them if they are sure if they can go in Spanish. And many times the person may feel like the urgency to get through their case, and they'll say, yes, I understand Spanish, okay, but that may not necessarily always be in their best interest. But also sometimes getting a translation or an interpreter means that your case is going to be postponed, and that could add days, if not weeks, to your time in detention, right? So there's just, again, huge ramifications in terms of what the migrant or respondent, as they're referred to in court, may actually be getting, and the information that they're receiving, but also what they're providing in terms of evidence to the judge. And again, just access to asylum or like the changing policies and impacts, we have seen firsthand how something that just comes out in the news, or like an immediate change, and the judges will jump on it and start acting on that, even if that policy or that decision is changed later, the harm has been done. And we saw that particularly in the summer of 2018, when a lot of the protections for survivors of domestic violence and gang violence were basically ended up giving up their claims because the judges said that at that moment that was not a qualification for asylum, and they would give up their claim and say, I don't want to be here anymore, so I'm just going to go. Another trend is, the access to the legal representation, as Ariel was saying. People who without legal representation are far more likely to be deported, or to be removed, or to abandon their case. And a lot of it, what we've started to monitor as well, is what we have titled or called self-deportations through the master calendar hearings. A lot of times do to prolonged detention. They don't have access to representation. They've had these language barriers. And what happens is that even before they are able to present their actual asylum claim, they ask for a deportation. And so we started to monitor that. So in our latest data, which we'll release shortly by the end of the year, we were able to, I think there was about 25% of migrants in the El Paso sector, the El Paso Processing Center, that ended up abandoning the relief before even presenting their case. So already the El Paso denial rates for asylum are very, very high, the denials. I think the track numbers for September 2019 was like 100% denial. It was usually between 96 and 98. And so you already have that very slow chance of winning your case. But then if you add all those who don't make it to that hearing and end up abandoning it, that's a large percentage of the migrants who are presenting before the court.
And I would just add to that, it's not just abandoning, right? Like very often somebody doesn't know how to fill out the application that they're expected to fill out, and so the immigration judge might rule it as abandoned, but those are all folks who, as Edith was saying, like those are people who are not going to be counted in the tally as asylum seekers who were denied because they didn't necessarily apply for asylum or apply for a specific form of relief. Can I add one thing just in thinking about trends to monitor too, I think, is I guess I'd encourage folks on this webinar and in general and engaged in Court Watch to kind of constantly be reflecting on what your networks are and where your power lies, because the trends that you capture often inform them, and I think we're going to get into this very shortly, but kind of the activity that you can get into after Court Watch or the advocacy you can partake in afterwards. So, for instance, if you're in a position to lead Know Your Rights presentations, because the immigration process or removal process proceedings are so complicated, it's often difficult to know exactly which rights to highlight with somebody who doesn't have a lot of time and isn't familiar with the system already. But if you're aware that certain judges make a pattern of violating a certain set of rights, that can then inform the way that you go about the Know Your Rights presentation. So just thinking through, not just what is the information that's important to capture, but also what do you expect to be able to do with it, or do you know others who might be interested in that information? And that will also help kind of think through what trends at your local immigration court you should be monitoring.
Yes. And the next page, and I know it's a little bit blurry perhaps on your screen, but you'll be able to access this through our website immediately after the webinar. This is the template that we had established for the last 2.5 years that helped us keep track of some of the trends that we were monitoring, right? So I think that this could be a useful tool. Now we're going to be having an improved version of it that's going to facilitate our tracking of it through Innovation Law Lab. So that's really exciting for us. But so far, for just general referencing material of what it could look like, this is what we did after we immersed ourselves in the immigration court system here, and long enough to know what information may be presented. Obviously, we know that many times, not everything, you're not going to be able to fill out, every single circle or box here, or have something, because some cases go very, very fast. But it's just so that you know that these are things that may present themselves. And one particular one that I also like to keep track of, and we started adding it maybe just last year or a little bit more than a year ago, was the time that someone is present before the judge. Because usually, as you may not expect, but some of these cases, even if those that have a little bit more information, go really quickly, like 5 minutes, I think is our average, including bond hearings, which tend to be a little bit longer, but that's not a lot of time. So if you think about, again, due process and everything, that's just not a lot of time. But also, as Ariel was saying with the case in Boston, and we see this here too, is that the time discrepancy between time in front of the judge and time on and off the record. We know some judges will stay on the record, which is the recording that will be transcribed and is on the record for that for a case. But some of the judges will go on and off of it and have discussions with both with the migrant or also with their attorney or with the ICE attorney. And a lot can be said during that time. And oftentimes when they go back on the record, they may summarize it, but a lot of information can be lost there too, right? So just again, having that accounting for that time, I think it's important, and it requires a little bit more discipline because you have to be constantly checking the time. So bringing a watch with you may be really important because you cannot rely on your cell phones, because in most places cell phones are not allowed in the courtroom. Anyway, so you can go through on our website on the manual through this, and then also hopefully if you're interested in also doing the court watch model, there's a little bit different, but you'll see it here as well. It can be really fascinating to just go through them. And in terms of how to use the data, right, or how to use this information, we have had a couple of ways that we've shared it before. We started in our 2018 report with Sealing the Border. We disclosed some of the information that we had gotten for that year there. So you can obviously use it to be able to quantify some experiences or some trends. Of course, knowing that these are snapshots of certain days, but if you do it the way that we have done it, in the way that's systematic, it is able to sort of prove this trend. So we're able to get some numbers that are pretty representative. But most importantly, numbers are good, but they're a good addition to a story, or that's the way that we've seen it have the most impact. And those you can't capture unless you're there, right? Including judges' quotes or what they're saying. So here we have an example by one of our most infamous local immigration attorneys, Judge Abbott, who's constantly going on and off the record. And so we're able to capture those quotes directly. And even without disclosing his name, sometimes we would just say a comment, and local advocates or attorneys will know who we were talking about just based on the content of the comment. So being able to track that, but also just like the stories of people, right? Again, it's a constant effort to humanize these stories, to tell and to advocate and have them be the best advocate when you're being able to capture that. And we know that there are resources available, including Track, which we use as well. They are incredible in terms of being able to capture numbers, but these sort of other elements that are more qualitative in nature aren't captured by the numbers alone. So for us, it's been important to have a little bit of both. And so now, Ariel, if you want to talk a little bit more about your fancy technology.
Sure. So this is our fancy technology. At Law Lab, kind of over the past almost year, since I want to say February of this year, and it's taken that long because we started with one design, and then there was a memo that came out that prevented folks from using electronic devices in immigration court, kind of anywhere within the building. And so that forced us to kind of come back to the drawing board. And this is what we've come up with. So the idea is that we start with a form that's very similar to the form that Edith showed on the previous slide, that can be filled up by hand. And the reason that we do this by hand is because, as we already kind of heard, EOIR doesn't allow folks to bring electronic devices into the courtroom. I mean, there are some courts, or actually into the entire court. So there are some courts where you'll find that in practice that's actually not enforced, but generally speaking, we wanted to create a program that allowed for court watch in any immigration court. So this is just kind of a sample of to show the format of the form. The form is scannable, and once it's scanned, what the tool does is it auto-transcribes your responses. One of the kind of pain points that we heard over and over again from court watch programs was that getting all of that handwritten data into a usable digital format takes a ton of time. And so the idea here is that the form gets scanned, it gets uploaded to the tool, and the tool actually can read through the form, identify where parts of the form have been changed, and auto-transcribe, and then it reassigns it to the person who filled the form out so that they can confirm that the transcription is accurate. And then, so that's kind of one way of tracking a lot of the quantitative data, but as Edith pointed out, there's a lot of information that we want to capture that's not necessarily quantitative. The quantitative data can be really powerful, but it's most powerful insofar as it helps us tell the story. And so we've also obviously left space for kind of free text or freehand notes. This is another example of some pretty unprofessional and really horrific immigration judge conduct. This is one of the judges who was recently promoted to the Board of Immigration Appeals. But in observing him, the observers noted that he made jokes at the expense of the person who had been testifying and actually called her experience of persecution or the sexual violence she had survived admittedly awkward. That was how he characterized it. And then he spent about 10 minutes going back and forth with the trial attorney, the attorney on behalf of ICE, speculating as to whether being abused by an uncle counts as domestic violence because it wasn't within the kind of nuclear household. These are the kinds of stories that I think immigration attorneys kind of get used to over time. This is the experience that they expect when they go into immigration court. And even for the folks who don't get, kind of jaded and cynical about the entire process, there's a lot of fear from immigration attorneys about coming forward and reporting these things because they have to go back into court with another client later on. And what they don't want is to report the judge for this, see that there's no accountability, and then go back before the judge who now might want to retaliate because they've reported him. The way that going back to the tool, the way that it works is you fill out the form, and the quantitative portions or the multiple choice portions are automatically transcribed, and then the text or the handwriting is kind of posted for you to type in your notes underneath. So you can see here we have, this is actually typed in because I did not handwrite it, but that, the font is supposed to look like it's handwritten. So that would be handwritten, and then underneath you can see that somebody has started to transcribe those handwritten notes so that they can be more searchable and more legible. The next step, kind of the reason that it's so important, I think, to digitize all of the data that we're collecting is because what it allows for is custom reporting. So any user of the CourtWatch tool can use, this is just one section of the kind of reporting functionality, but the idea is that any user can then, oh, can we just go back? Yeah, thank you. Any user can then filter and aggregate data in real time. So anything that gets captured by those forms and then transcribed, a user can then go through and kind of select, okay, I want to see the responses to these questions, and I want them filtered by these other questions. I still haven't figured out how to explain that articulately and succinctly, but would be happy to take some more time at some later date to describe that a little bit better. The idea really is to allow like grassroots organizations, litigators, people who are writing academic reports or organizational reports, to filter through the data and kind of access it as easily as possible and as efficiently as possible.
Yeah, so at the end, I think that both tools, one kind of facilitates the processing for the other. If someone chooses to do that, right? Go back to the use of the information, the use of the data, right? So in what we have sort of just talked about in advocacy for immigration justice, we've perhaps focused a lot on media campaigns or legal challenges, but it's also a really good way to organize within your community or within your school about the issues, right? And being able to come together and sort of share this. It also is a really powerful tool to raise awareness and educate your community as to what is happening. I believe that no person who has gone into one of these court hearings with us to observe hasn't come out completely changed or moved by what they have seen. And not only do they now go and share it, they become like an advocate for it, but they oftentimes are so intrigued by the horrific things that they just witnessed that they do their own research or whatever it is that it comes out of it. It's transformative. And so that's why to us it's important for people to have access to these resources, and for you to really go through it and figure it out what makes sense for you and your community, what you're trying to do. It can have multiple uses. You can do it and just to observe, just to be able to show support for migrants, but you are going to be able to have a wealth of information, and you can choose to employ that in many different ways. Ariel?
I think that's right. I think the organizing piece is a really key part of it. Immigration courts and court in general, I think, has kind of this veneer of professionalism, this assumption that due process exists within that space. And it's one of the parts of the deportation machine that I think is most opaque. So immigration court observation, it kind of helps us as kind of local communities, but also as a national community of advocates, to really understand how this really important step in the removal process or in the deportation process plays out. Not just so that we can engage in litigation, not just so that we can have media campaigns, but also so that we can organize our own communities and have a better understanding of the issues that we're trying to tackle.
Yes. So here we have, I know we're coming up close to the Q&A portion of it. Here we have just some resources. As I mentioned, we're going to be sending this webinar through our email as well, but you can access it. You can also access the manual through our website. It's going to be featured on the front page today. And so you can go to it then. We'll follow up again through an email. And then this is also some of the wonderful resources that Innovation Law Lab has. So and those, as you can see, if you choose to engage in that sort of organizing, and then you decide that you want to have this be like a more robust, ongoing systematic project, then Innovation Law Lab's Court Watch app is really going to be a useful tool, and we can help you talk through what that may look like in the future. So just because of times, we're just going to jump into questions. Diego is going to help us monitor those and make sure that we get through multiple.
So if you have any questions, you can always send them through our Q&A window or through the chat, whichever is easier for you. Let me double check here. Right now we have a question about the resources. I know I already answered that. So all the resources and visuals that were available during this presentation will be available through our website, hopewater.org. And our main page, you'll find a link there that will take you to the manual where you can have all this and a little bit more explanation, go into depth. We also have a question from Andres Lopez. It says, Hola, Edith, hope you're well here in El Paso. I haven't taken groups to the federal courthouse to observe into the court hearings, and I probably missed it, but can people attend immigration court too, or only the initial court hearings?
Yes, so the federal court ones, that's another another component that will also be interesting to observe. But right now, the way that we track it is the immigration court, and so for those, the master calendars, which are anytime between your initial appearance of a migrant or respondent until the time that they actually submit their application, those you can attend, typically without notification to the court or without permission. They're open to the public. So those and the bond hearings are open. So what I usually advise people is, and again, this will be more laid out in the manual, is checking out the EOIR website for your location, looking at the times. And what I often do is just call up and without, just asking the court clerk what the schedule looks like for that day, so-and-so a judge has something, and then just showing up. Again, being aware that there might be some pushback, there might be this, but as more background reading that you do, and the more times you do it, it'll become easier and easier. But you can have those, particularly with groups, without too much problem. The only issue would be, at least in the El Paso detained court, it is the size of the group, and sometimes there's limitations as to how many people can go in at once. depending on how many people are going to be in front of the court.
Great. Another question would be, in general, have varied our judges' behaviors in different cities?
So how different do they act?
Yes.
Do you want to answer this one, Ariel?
Sure. I mean, I think it's between different cities, it's between different regions, and it's also within immigration courts, right? Like I'm sure in El Paso, you have some judges that are awful and some judges that are maybe a little less awful. And I don't know that I've heard of any judges that people get excited about in El Paso, or that they're happy to find out that that's the judge they've ended up with. In Atlanta, we have some judges who are very notorious, and then some newer judges who are much more professional. And then you have jurisdictions where the judges actually take pride in the fact that they are very professional and that they do afford due process and that they are able to be efficient in the courtroom and still observe someone's rights. So it's a great question, and it's totally unfair, but the truth is that who you end up with as a respondent in removal proceedings makes a huge difference in how your case is likely to turn out. And that's between cities, and it's also just between courts within the same city.
And we have another question, one for Edith and one for Ariel. First, Edith, what is Hope's goal, if there is one, for the amount of court cases observed? Are we seeking a certain level of observation to generate robust findings?
Robust findings. Yeah, well, I think that we have a multi-pronged approach and goals within it. I think the ultimate goal is to have a change in how in the immigration court system, right? So the first is, of course, the educational and awareness component to us. It's key, particularly with groups that we have. But we've also been able to make it sustainable through the participation of UTEP, the University of Texas at El Paso's classes. And again, that kind of functions as awareness, but also learning about research methods and all of that. But the more information we're able to capture, the more that we have evidence to support the changes that we're trying to promote, which is, again, transparency and accountability. It just access to information and to uphold the rights of respondents, I think. And so whether that looks like having campaigns to better educate judges, or have demand certain changes which in how they're trained, how they're hired, through that process, or perhaps even in some cases if they're able to be removed because of all these allegations, and we have the robust information to have it, we're able to create that. So I think we have a couple of what I would call more immediate goals that we want, but at the end of the day is to see and to create that change within at least the immigration court system, which we'll be able to through the smaller or goals or changes in between.
And this question is for Ariel. If you could provide any more details about the Atlanta judge who was observed making racist jokes off the record. What was that judge's name, and when did he step down from court?
So that story is actually about a judge in Boston. His name is Judge Ragno, so that's Ragno. And I don't know when he stepped down. I believe it was I think it was like 2010, if I had to guess. But if you search immigration judge Ragno, Ragno, and then actually I think the article that comes up, so just to kind of round out that story, he had spent years and years abusing his power in the courtroom, and what finally brought him to the attention of the media was a dean of medicine of a local medical school who was brought in as an expert witness, heard him making a joke about the respondent was a Ugandan woman named Jane, and so Judge Ragno stopped the record to make a joke about Tarzan and Jane, which is deeply unprofessional, but also like pretty tame by his standards. That like he's made way worse jokes. But this dean of the medical school was so profoundly offended, and he called a press conference to talk about what he had seen. And then when the journalists started, when the kind of questions came up about whether this was a regular thing, there were years and years of documented reports of him making even worse jokes, and kind of worse comments. So yeah, I would look up Immigration Judge Ragno, and it shouldn't be too hard to find stories about him.
And I think I have a question for Monica. Where the court hearings usually held? I think she means where are the court hearings usually held?
Well, I think that depends on where you're in the jurisdiction, or where, like, what community you're in. So again, if you go to the EOIR website, and that is the EOIR is the Immigration Court, the Executive, I have to spell it out, EOIR, Executive Office for Immigration Review. You can look up your state and your city, and you can see the locations, right? So for instance, here in El Paso, we have, in the area now, we have the detained dockets that are part of the El Paso Processing Center. We also have one in Otero, and then there's a non-detained docket that is in the downtown of El Paso. Right? So those are 3 different courts, but it depends on where you are.
Okay. Oh, and then we have another question from Max, who's, if we are generally not there to observe individual hearings, I'm not clear what we're actually observing.
For the individual hearings or the merits hearing, so we will be separate. So what we are observing would be the master calendar hearings and the bond hearings. So if you go back in the presentation, and once you're able to go through our manual, you'll see that is explained in one of our infographics or flow chart. So you would be observing anything that happens between the very first time that a respondent is before the judge to the time that they submitted. And throughout those times, again, if you go through our template or our CourtWatch template, you'll see that you'll be able to monitor the use of language, whether the judge read the rights, what types of rights, whether they were seeking in terms of relief from deportation, whether that's asylum. Not everyone is an asylum seeker. You also have some cancellations of removal for folks who have been living here for a while, right? So you're able to sort of mark some demographics that you can keep track of, as well as any of this type of behavior that Ariel was just discussing in terms of judges. And there's a wide range of other things that you can observe, depending on your filter, on your personal interest as well. We had one of the students from UTEP, a couple of them, they were more like anthropology graduate level students, and they did a whole story of like interaction between the guards outside, right? So everyone kind of has like a very interesting and can take a unique use of that information. We like to quantify certain things to be able to have access against that demographic of who's there. And it goes back to the reason why we decided to observe. So I think it just depends on your individual community's needs and desires to do this.
I want to thank again Ariel, Prado from Law Lab, and Edith Tapia from Hope Border Institute